Hello and welcome to another Fact Friday. Today is June 6th, and this Fact Friday is about fiduciary duties. Now, this is not a really exciting topic, so we're going to go through this pretty quick for this Friday's episode. But the reason why this is important is we're going to have the board elections coming up soon. We need to think about what all has occurred this last year and how we don't want that to happen again. And part of it is just making sure that the people that are elected to fulfill any openings here understand what fiduciary duties are and their responsibility to maintain their loyalty and their integrity to this association. So, what exactly are fiduciary duties? They usually fall into a couple categories like duty of care, duty of loyalty, and stuff. But generally, these are the top six: duty of care, and that's to make informed and thoughtful decisions, to research issues and seek expert advice before acting. There's the duty of loyalty, and this is to prioritize the interests of the association and the property owners over any personal interests or agendas. And the duty of obedience. Now, this is following the law, and the law can be property code, it can be business organizations code, it can be penal code. Also, our bylaws and our governing documents. Duty of transparency. This is to share truthful and complete information with members. And some information the members actually have a legal right to. So definitely whenever like a records request comes in from property owners, those need to be handled truthfully and completely. Fifth duty is the duty of honesty and good faith, and that's avoiding misleading or dishonest communications. We've had a couple examples this year where a board member was reading either statute or documents, and they were reading selectively. While they were reading, they were editing out the parts that did not fit with their argument, and so that's dishonest. We need to not have that happening. And six is the duty to act within authority. So the biggest example there was the incorporation without it being authorized by property owners or the board. Other indications of that were the unauthorized amendments. There were ones in November of 2023 and March of 2024. We had another in September. We had another just this May, which was to try to fix the previous amendments. But in the process, Kelly Rom, our chairman, went ahead and changed previous amendments without a property owner vote. So, in the process of trying to say, mea culpa, and I will fix this, she actually caused a fourth unauthorized amendment. So these are the six basic fiduciary duties. And generally, they go into those four classes: duty of care, duty of obedience, duty of loyalty, and duty of transparency. These are really the minimum requirements for somebody who's going to serve on the board. You want to say that I'm going to be paying attention, I'm going to do the best that I can, I'm going to serve in the interest of the community, and my actions are going to be transparent. Now, let's examine some specific violations committed by Kelly Rom and Kelly Harrell over this last year. These actions represented serious breaches of the fiduciary duties entrusted to board members, and they've had significant implications for the association. So, there's been a breach of trust, this undermining of community confidence. This includes preventing some property owners from voting, like when Kelly Rom actually pulled a ballot out of a property owner's hand this last ballot. There was no reason why a property owner could not vote in person. You know who this person is. You recognize them. There's no reason why they can't vote. And in fact, the wording on the ballot stated from property code that a vote in person would override a absentee ballot, indicating that a in-person vote was still in play. Uh, Also putting out false information at board meetings. We already talked about that. Whether these are, they just, they don't, they're just misunderstanding property code, or they're putting out things that with just a minimum amount of diligence, they would realize that what they are reciting actually doesn't apply to property owners. Or, for example, at one of the board meetings, Kelly Harrell read out loud what it means to be a property owners association. But the definition she read, I couldn't find anywhere. I took it word for word and tried to find it from Google. Did not come from a true, like, legitimate resource. And it contradicted exactly what property code, Texas property code, states in its definition of what a property owners association is. So there's been a breach of trust here from the misinformation being put out and the selective editing of information that is put out. The unauthorized actions obviously are a breach here. There are rules in place for a reason, and it's to prevent overreach and abuse of power. And then legal violations, disregarding the laws and bylaws, discriminatory enforcement, and using the position of power to try to intimidate property owners. So let's get back to that biggie because this is what the civil lawsuit is about. It's about the unauthorized incorporation. So this was the corporation attempt that happened May of 2024 that did not result from a board or a property owner vote. In fact, in one board meeting, Kelly Harrell actually stated that it was just on her own authority. She stated Kelly Rom didn't even have anything to do with it, which is a problem because nonprofit corporations in Texas must have the founder and at least two other founding board members plus a registered agent. So, unlike, say, states like Colorado, where they allow a nonprofit corporation to be formed by one person, the here in Texas, it's a minimum of three. So it could not be done on her own authority. And one of the people that she had listed on the document never consented, and Kelly Rom was listed as the registered agent. So I don't know how Kelly Harrell states that this was all done on her own authority and Kelly Rom had nothing to do with it. None of this makes sense. So this was the biggest breach. It was a breach of the duty of obedience because they were not following our bylaws, our documents, property code, or the will of the property owners. It was a breach of duty to act within authority because there was no legal authority to fundamentally alter the association's legal structure without some kind of governance here from the property owners or the board. And it was a breach of duty of loyalty because acting unilaterally to change the structure may have served a personal or external agenda, but it was not reflected by the will of the members. And then we're back to the unauthorized amendments. The initial unauthorized amendment from Kelly Rom was November of 2023. There were additional ones through 2024, and now one in May of 2025. The additional violation was where she filed an amendment to correct previous amendments, which I would support her if she was correcting the ones that she falsely filed. But she also went back over a decade to correct somebody else's without a property owner vote. You can't change these bylaws, CCRs. You can't change our governing documents without a property owner vote. So, number fourth unauthorized amendment. And a lot of these changes have been hidden until they've been brought to light by the property owners. So that includes the corporation. It They incorporated in May. It was never acknowledged to property owners. It was only acknowledged to other board members in September. And little fact about that, I was on the Secretary of State website because of my corporation that I run. I was filing an information report and got curious, and I was like, well, let me just take a look at it and see the history of the filings for Camp Branch Acres. And that's whenever it popped up that it had been incorporated in May, and I became a property owner in May. I know that I didn't vote for that. I know that there wasn't any discussion about that. So that's a problem. Speaking of people that weren't notified about the incorporation attempt, one was the new treasurer. So in June, Charlene was elected as treasurer, and she was not informed that the association she was doing bookkeeping for and would be expected to file taxes on had been incorporated. She did not know until everybody else found out in September, and it wasn't ever disclosed to the property owners until much later after that, once these discussions started happening in the board meetings. specifically the property owners addressing the board about their concerns. Another breach, fiduciary duty, it's the breach of the transparency duty, are the records requests and the misinformation. So there's been numerous times that I have tried to follow up on the records requests that I started in October of 2024. Generally, whenever I send a list of what documents are still missing, what information still hasn't been disclosed, they either try to blame Charlene for it when she didn't have access to the information, or they just start attacking me, my family, my spouse, my friends. And so this is a violation of Texas property code. Property owners have a right to the financial records of their association. The other is just the misinformation spread. We First episode of Fact Friday was nothing but audio clips of the board said this, and then here is the actual statute that contradicts what they said. And the board said this, and this is the actual definition from property code that contradicts what they said. The whole first episode, and it was like 40 minutes long, was basically this is what's been said, and this is why it's not true. And this is what's been said, and this is why it's not true. And even at this last meeting, there's still stuff being put out there. We're not a nonprofit, is what Kelly Rom stated. Chapter 252 of the Business Organizations Code here in Texas, the Unincorporated Nonprofit Association, states that you don't file with the Secretary of State. There are two discretionary filings that you might file if you want to, but the organization of people as an unincorporated nonprofit association, which gives them a legal entity status, just falls from their identity document, which is our CCRs, our bylaws. And then basically for banking purposes, you're going to want an EIN just so that you can, it's like an identifying number, right? So read Chapter 252 of the Business Organizations Code. It's not long, it's like 5 real pages, and it talks about here are the rights of an unincorporated nonprofit association. But at the very beginning, it explains how one is formed, and it is people come together for a common nonprofit purpose. And a nonprofit purpose means that nobody's going home with a check labeled profits. Nobody has profit distribution. We don't have shareholders that are expecting to get a profit distribution. We don't have investors that are expecting to get return on that investment. We are nonprofit, which means our money goes back into our goals here in the association, which is keeping up our community. And that is a legitimate nonprofit purpose. The other one was that banks won't work with us without a franchise tax exemption. Just spoke with US Bank, not a problem. Unincorporated nonprofit, they just need a copy of our bylaws and a current EIN. That's it. Now, when you are a corporation in Texas, the franchise office reaches out to you and makes sure that you know that if you make over 1.23 million, that you need to pay some franchise tax. And if you aren't going to make that much, then they still need you to file as a corporation that you haven't made that much. But it's actually not it's not a thing for an unincorporated nonprofit association. And we don't need the exemption when we're nowhere close to ever having to pay franchise tax. The third misinformation was somehow, whenever they were discussing that third ballot, the first ballot was to remove Charlene from the board, which the property owners overwhelmingly voted against. The second ballot was to remove Jerry Sullivan from the board, which the property owners overwhelmingly voted against. The third ballot was, do you want to be incorporated, which the property owners overwhelmingly voted against. In fact, I believe every vote since the last election, since the last board election, I believe every vote has gone against the will of the people running the board, which is the trio. So the vote is about not following up on the forged document. And that's not correct. There was nothing in the wording of that ballot about the so-called forged document. The vote was, do you want to be incorporated or do you want to remain unincorporated? And the property owners stated that they did not want to be incorporated. To try to reshape this as somehow telling Kelly and Kelly that they don't need to follow up on their investigation is incorrect. If that document was forged, then I recommend they follow up on the investigation. There's no reason for them not to. But that is their corporation, not our association. That is their issue to follow up on. It actually has nothing to do with our board because they formed a corporation. Kelly Harrell is the founder. Kelly Rom is the registered agent. It wasn't authorized by our association. It's not attached to our deeds. That is their own corporation over there, and those issues they need to follow up on. So back to why does this episode matter today? Well, fiduciary duties matter. They're not optional suggestions, but they are legal and ethical obligations that protect our community. When board members violate these duties, the consequences extend beyond paperwork to the very foundation of community governance. It can bring up legal liability. These violations expose the association to potential lawsuits and financial penalties. It affects our democratic processes because violations undermine our voting rights and our community decision making, and it violates our community trust because these breaches damage the relationship between board members and those they were elected to serve. To serve, not to rule over. Our path forward is to get the community involved. This May 29th vote to reject the unauthorized corporation was a crucial step towards accountability, but this vigilance must continue. The community spoke clearly, and board members must now take specific actions to restore trust and proper governance. Correct the previous false filings, disclose all amendments, comply with records requests, and I encourage the concession of the civil lawsuit. Yes, Kelly and Kelly are the defendants, we're the plaintiffs. They can concede. What we're asking for in the lawsuit is judicial dissolution of the unauthorized corporation and to prevent it from just magically being reinstated after the end of the lawsuit. Those are pretty reasonable requests, especially whenever you consider the vote that just happened when property owners stated they don't want to be incorporated. So I'm not sure why we as plaintiffs are not going to drop the lawsuit because I'm suspicious that if we do, then they're just going to reinstate their corporation and we're back to square one. But as defendants, they can concede. They can do it's a confession of concession or something like that. It's something that you can file and you can just say basically go ahead and rule like we're not fighting it. We concede, and that would be great. Now, yeah, y'all do what you need to do, but my point is not conceding just shows that you do not have the property owner's interests in mind. You're not listening to the property owners and you're not being loyal to the votes of the property owners. So, in order to move forward, we need to not repeat the mistakes of the past. We need to elect individuals who are interested in serving the community, serving, not power. Elect individuals that will do the work of research and will seek opinions from experts. Elect individuals who will be loyal and obedient to the property owners and will protect the rights of the property owners. We also need board members whose word is good, that when they state that they agree to something, they agree to it, they don't backtrack later. That when they give their word on something, that their word actually means something. And this is interesting because I've heard a couple times from a couple of the board members that, that I feel aren't representing the community, that we can't do business on a handshake. And this community has done business on a handshake for a long time. That's because we were always able to reach out to our neighbors and know that their word was their word. Their word was their bond. And a handshake meant something. So I wouldn't disparage doing things on a handshake because when a community can give their word or shake hands over something and make it happen, That's a community that works together and that works in unison. And there's nothing wrong with that. I want to thank you for once again listening to me. I can be reached at jenharristx@gmail.com. I'm on YouTube. You've probably found this. This is how you're listening to this. I also administer the cbapoa.org website, which used to be the official website and may be down the road, but right now is considered the unofficial website, and it does contain historical documents and current information for Camp Branch Acres. I'm also one of the administrators of the Camp Branch Acres Residents Facebook page. That is Tim's group that I'm one of the co administrators with. And you can just go to Facebook and search for Camp Branch Acres Residents. Thank you so much. I hope you have a great weekend.